It all started with a bird feeder, not a garish, neon pink one. A tasteful, handcrafted cedar house my grandfather made. I hung it from a tree in my front yard. A little piece of family memory. The birds loved it. My mornings were filled with the cheerful chirps of chickadees and finches. The serenity lasted about a week. The first letter arrived, printed on the HOA's official violation notice stationery, which I'm pretty sure is just regular paper sprayed with the scent of superiority. From the desk of Beverly Cranston, HOA President. Subject: Unauthorized Wildlife Attraction Device. Code 8D. Dear Resident, it has come to the board's attention that you have installed an unapproved apparatus for the purpose of soliciting wild fauna. This violates Community Standard 8D, which prohibits any device or fixture that may attract non-domesticated animals, thereby creating a nuisance or biohazard. You have 72 hours to remove the violation. Failure to comply will result in a fine of $75. Beverly, the Vulture Cranston. She patrolled the neighborhood in a golf cart, clipboard in hand, a look of profound disappointment permanently etched on her face. Her HOA bylaws were her Bible, and she was its vengeful, micromanaging god. I tried to be reasonable. I went to the monthly board meeting. Beverly, I said, calm as could be. It's a bird feeder. It's for songbirds. It's not a bear bait station. She peered over her rhinestone-studded glasses. Rules are rules. First, it's a bird feeder. Next, someone will be leaving out salt licks for deer. Then we have raccoons. It's a slippery slope to anarchy. She wasn't joking. I could see the genuine fear of impending raccoon-based societal collapse in her eyes. I removed the feeder. My daughter was sad. I was annoyed. But I figured, pick your battles, right? Oh, I was about to pick the battle of a lifetime. Removing the feeder wasn't enough. It was a sign of surrender. Beverly, sensing weakness, went for the jugular. The next violation was for my lawn. It was a healthy green, but according to Beverly, it was the wrong green. Serenity Estates green, as defined by a specific Pantone shade, was the only acceptable hue. My grass was apparently 2 shades too vibrant.
Fine. $150.
Then it was my mailbox. A standard, black, colonial-style mailbox. But the hinge was brass, not nickel.
A non-conforming hardware fixture. Fine. $100.
Then it was the unauthorized emotional display. A rainbow flag my niece had stuck in a flower pot for Pride Month. That one came with a $250 fine and a strongly worded letter about maintaining a neutral community aesthetic. The fines were piling up. Letters turned into threats of liens. My neighbors, whipped into a frenzy by Beverly's gossip, would cross the street to avoid me. I was the neighborhood pariah, all because of a bird feeder and the wrong shade of green. I paid the fines under protest, but something inside me snapped. This wasn't about rules anymore. This was a crusade, and I decided to become a scholar of war. I became a ghost in the machine. While Beverly was policing grass length, I was buried in the Serenity Estates covenants, conditions, and restrictions, CC and RS. All 243 pages of soul-crushing, legalese tedium. I documented everything, every letter, every email. I recorded conversations. My state is a one-party consent state. Thank you very much. I created a timeline of her harassment. And then I found it. The motherlode. The key to everything. Beverly, in her infinite wisdom, had spearheaded a new community enhancement project. She wanted to build a row of 12 luxury guest villas on a vacant, wooded lot at the edge of the neighborhood to generate HOA revenue. The plans were approved in a shady, sparsely attended meeting. The construction was about to begin. The lot was labeled on the HOA maps as Parcel B Common Area. But my late uncle, a paranoid and brilliant man who left me this house, had also given me a thick envelope of old documents. As I sifted through them, I found a survey map from 1952 and the original land grant deed. The Parcel B the HOA was about to build on, it wasn't common area at all. It was a 5-acre, landlocked parcel that had never been annexed into Serenity Estates. It was deeded to my uncle, and upon his death, it passed to me. Beverly Cranston was about to build on my property. A normal person would have stormed in, deed in hand, screaming stop. But I wasn't a normal person anymore. I was a patient, paperwork-wielding phantom. I hired a surveyor to confirm it. He did. The land was 100% mine. So I made a decision. I said nothing. The bulldozers rolled in. Trees came down. Foundations were poured. It was a symphony of destruction, and I had a front row seat. Every morning, I drink my coffee on my back porch, listening to the beautiful, illegal sounds of construction. Beverly would send me smug emails. Progress on the new villas continues, a testament to what we can achieve when we all pull together. I'd reply, can't wait to see the finished product. Smiley face. The villas went up. They were hideous, enormous Tuscan wannabe monstrosities that looked like they'd been rejected from a timeshare brochure. But they were almost finished. The for sale signs went up, and pre-construction sales began. The HOA was about to be flush with millions of dollars. My phone rang off the hook. Lawyers for the pre-sale buyers, doing their due diligence, would call me as an adjacent landowner. Just a formality, they'd say. I'd be cheerfully evasive. Oh, it's certainly been interesting to watch it all come together. The day the certificates of occupancy were issued, I knew it was time. The trap was set. The cheese was on the plate. And Beverly, the big, dumb mouse, had taken the bait. The HOA threw a grand opening gala. For the villas, there was a ribbon. There was cheap champagne. Beverly was there, holding court in a pantsuit that could deflect small arms fire, beaming with pride. I walked in, dressed in my best jeans and a clean t-shirt. I carried a simple, legal-sized folder. Beverly, I called out, my voice cutting through the chatter. Congratulations on the new villas. She turned, her smile faltering for a second before snapping back into place. Well, thank you. It's a great day for Serenity Estates. A pity you couldn't have been more supportive during the process. Oh, I was supportive, I said, my voice calm. I found the whole process fascinating, especially the part where the HOA built on private property without permission. The crowd went quiet. You could hear a pin drop. Beverly scoffed. Don't be ridiculous. This is HOA common land. Parcel B. See, that's the thing, I said, opening my folder. I pulled out the 1952 survey and the original deed, handing them to her. According to the county registrar, and confirmed by a licensed surveyor just last month, Parcel B was never part of the HOA. It was deeded to my uncle, Arthur Pembroke, and is now my property. You've just spent the HOA's reserve fund and the money from these pre-sales to build 12 illegal structures on my land. Her face went from smug to confused to pale to a shade of purple I'd never seen before. This is a forgery. This is slander. It's a court-admissible deed, Beverly. And the best part. I paused, looking around at the stunned faces of my neighbors and the terrified-looking pre-sale buyers. Adverse possession requires 20 years of open, hostile use. You've been here for 18 months. You're a little short. It didn't take long for the lawsuits to fly. But they weren't suing me. I was suing them. The courtroom was packed. The HOA board, their lawyer, the lawyers for the buyers, and a whole host of nosy neighbors who suddenly remembered my name. The HOA lawyer tried to argue that it was an innocent mistake, that the maps were confusing. My lawyer, a shark I'd hired the day after the gala, simply stood up. Your Honor, this was no mistake. The HOA president, Beverly Cranston, was repeatedly made aware of property line disputes in the past, as evidenced by these meeting minutes. She chose to ignore them and proceeded with a multimillion-dollar project on land she had no title to. This is gross negligence, if not outright fraud. He presented my timeline, my documents, the surveyor's report. It was a slam dunk. The judge, a no-nonsense woman who looked as bored by HOA drama as I was, finally spoke. The chain of title is clear and uncontested. The plaintiff is the legal owner of the land in question. The constructions are unauthorized. The HOA is liable for all damages, including the cost of demolition, land restoration, and any lost rental value. The gavel came down. The sound was more satisfying than 1,000 chirping chickadees. The fallout was biblical. The HOA's insurance didn't cover this level of stupidity. They were bankrupt. The villas had to be demolished. Beverly Cranston was not only removed as president, but was personally sued by several neighbors who lost their life savings in the pre-sales. The new HOA board, which I was politely asked to join, I declined, immediately set about dismantling Beverly's reign of terror. The bird feeder ban? Gone. The lawn color code? Abolished. The entire CC and RS were rewritten with an emphasis on, not committing felonies. As for my 5 acres, after the rubble was cleared, I had it declared a protected wildlife sanctuary. I put my grandfather's bird feeder right in the middle of it. The birds are back. The silence, now, is truly serene. So, the next time your HOA gets on your case about your garbage can being out 5 minutes too long, just remember my story. Sometimes, the best way to win a war isn't to fight the first battle, but to let your enemy build their own gallows. All you have to do is provide the rope, or in my case, the deed. Thanks for watching. Stay calm, document everything, and know your property lines.
Outro music fades in.
End screen, subscribe button, links to other videos titled, I used HOA bylaws to destroy my HOA, and neighbor stole my land, so I took their house.